All right, everybody, we're going to get started. So my name is Doug King. I'm a lawyer here at Pivot Legal Society, and I'll be the host of today's webinar discussion. A couple things. I'm going to get started here then. So thanks, everyone, for joining. My goal here today is really to give you a little bit of a rundown on how some of the things that your clients experience and some of the history of violence that they may have experienced will impact their relationship with specifically welfare and housing in the province and the government systems that we have to access those things. So first of all, by way of background, like I said, I'm a lawyer here at Pivot Legal Society, but before I became a lawyer, I worked as a community advocate in the Downtown Eastside for an organization called the Downtown Eastside Residents Association. My job there was kind of frontline advocacy, and it was really designed to help anyone with whatever problem they had coming in off of the street, just drop-in style. So through that job, I really learned very quickly a lot about the welfare and housing systems in our province and how they often are very difficult to navigate, especially for marginalized people. So through my time through there and through my work here at Pivot, we've really started to analyze, I guess, the best ways for our clients to interact with the system and to try to avoid some of the kind of common pitfalls that we see. So I'm going to start by talking a little bit about the welfare system. Obviously, for some of you, you may already have some experience in this area. You may have dealt with clients who have interacted with the system or know a little bit about it. Sometimes what I'm going to say is going to sound pretty basic, but I think it's important to kind of set the stage a little bit that way before we talk about some of the specifics of how really, I think what we're going to focus on today is how does that question of violence against women and violence in a relationship impact your ability to access those services. Part of these slides and part of these questions and presentations is actually based upon we had asked some of the participants in our last live discussion about what they see the most of all and the questions that come up the most for them, and that's kind of what this talk is catered on. So likewise, if there's anything specific that you kind of came to the webinar hoping that you would hear about or that you want to ask a question about, definitely feel free at any time to do so. So starting with the very basics, welfare in the province right now, its official term is income assistance, is a two-stage process. What a lot of people don't realize is that most cases, the average case, you can actually walk into a welfare office and immediately be placed on income assistance. There's now currently a 5-week waiting period for new applicants, which is called the work search period, and that's stage 1 of the application process. And in those 5 weeks, you're expected to actively search for employment, try to find work, and prove that in order to show that you're in need of income assistance. This is an increase that just happened within the last 6 months, and it's an increase from 3 weeks of where it was before. And currently, if you were on income assistance before, if you've been through the process and you're returning, you're down to a 3-week wait, like the way that it was before. So obviously, this is the first initial barrier that a lot of people encounter when making an application for income assistance or trying to seek benefits. So one of the most common questions that we get asked, especially when it comes to people who have experienced violence, who are leaving relationships of violence, who have entered the transition house system, is how would you get around that 5-week waiting period? Who is exempt from that period? So what happens is welfare conducts what they call an immediate needs assessment. That's their language for it. And what it's designed to do is to try to, I guess, get people who have an immediate need for assistance, who can't go through that waiting period, and who have immediate housing and shelter and kind of food needs, to jump the line and to get that assessment done immediately. One group of people that has been specifically identified by income assistance as needing to have that immediate need and being able to skip that line is persons who are fleeing situations of abuse. And one of the most important things to realize in that is that it doesn't necessarily confine to physical abuse. If somebody is fleeing a situation of emotional violence, they also have that eligibility to bypass the 5-week waiting period. And one of the other questions that's commonly asked is if somebody is fleeing that situation, do they need to have proof? Do they need to have a police report before they can basically convince welfare that they're in need of support? That's not actually the case. You don't need to have that, and in many cases I actually discourage people from waiting to receive documents, especially from places like the police, because whenever you're dealing with government bureaucracy, it can take quite a while. So one of the first areas where I think a lot of people who work in the transition house system and who work kind of generally supporting people who have left situations of abuse is they can help them put those reasons in writing. They can help give them account of the situation, both physical and emotional, that they're fleeing. And putting it in writing is an easy way for them to approach income assistance. And if you have your assistance in that writing, then I think income assistance always feels a bit more inclined to believe somebody if they've sought assistance and if there's a transition house backing them up. So like I said, you don't need to necessarily wait to gather evidence. What you want to do is put whatever you can in writing, and hopefully the client will be able to convince the ministry that they're in a situation of immediate need and they can bypass that period. That being said, that's how the policy and the system is supposed to work, and sometimes it's very different from reality. And I'll try to kind of highlight situations where, in my experience, I've found reality often doesn't mirror what policy says. This is unfortunately one of them. The way policy says is that an immediate needs assessment is supposed to be done within 24 hours, and somebody is basically supposed to be able to walk into an income assistance office. If they're found to have an immediate need, they should walk out of that office with a check. Often that doesn't occur for a variety of reasons, and one of the other questions I get asked is, well, what can you do about that if it doesn't happen? This is one area that the ombudsperson has actually very specifically been targeted to address, and this policy actually came out of ongoing dialogue with the ombudsperson's office. So I usually refer people to file a complaint with that office and let them know if their client tried to access those services and was denied. For those of you who aren't familiar with the ombudsperson's office, it is a government office, but it's meant to be kind of separate and independent from government, and its role is to essentially try to mediate disputes, try to force government to adopt more progressive policies, and be a bit of, I guess, a mediator in between people who are trying to access services and the government who is providing those services. In situations like this, they can actually be quite effective, so it's a good thing to think about. So if somebody is successful, either waiting out the 5-week period or is able to bypass that, then they move on to stage 2 of the application process. Stage 2 is really designed to, hang on a sec, here we go, is where the actual eligibility process comes in, and this is the other place where a lot of people experience barriers in accessing services. At stage 2, after you've done your kind of work search or bypassed that, you're meant to look at the factors of whether or not you're eligible for assistance, and some of those I've listed here. This is definitely not an exhaustive list. There's actually quite a lot of different things that people need to kind of fill into, and unfortunately, I think because of the span of this talk, we're not able to go into everything, but this should give you a little bit of an idea of the eligibility issues that come up, especially for people who are experiencing violence. The biggest one is the 2-year financial independence requirement, and this was really designed so that people who were applying for income assistance could prove that they weren't coming from a position of dependence into government dependence. Obviously, when that requirement was created, it was completely unrealistic and kind of, I think, ignorant of the situation that a lot of people who are fleeing a family situation or a sponsorship immigration situation that involves violence or abuse were in. And that 2-year financial independence period is also something that can be waived if there is proof or an allegation that the person is coming from or out of a violent situation. Identity and citizenship is another really tricky one. There is an increasing number of different immigration statuses and certificates and places where people are, and they often don't fit into the kind of the basic, are they a Canadian citizen, are they not? And there's actually quite a few complications when it comes to that. I don't want to necessarily go into that because I think it kind of it strays a bit from what our topic is going to be today, but as you'll see in the next slide, or in a couple slides, there are some specific situations that you want to keep in mind when it comes to somebody who's in a sponsorship situation, for example, and how that might affect their applications. The third one, no outstanding warrants, is unfortunately a new rule that came in last year or the year before and has been enforced quite a bit by income assistance. So if somebody comes to your office and says, they're worried because they do have an outstanding warrant, unfortunately at this point you do have to advise them that welfare will ask for their consent to run a records check to look for those outstanding warrants. And if they're able to find an outstanding warrant, that will basically uniformly prevent them from accessing assistance. And typically speaking, the way to get around that, or the way to deal with that, is that person is going to have to try to find help on the criminal side if it's a criminal warrant, or on the immigration side if it's an immigration warrant. And that person, if they try to waive in their charge, if they try to actually proactively deal with the charge, I've had success with income assistance allowing that person then to receive benefits. But unfortunately, it's still a bit of a gray area, and for the time being, a warrant would definitely act as a barrier to them receiving benefits. And the last thing there is obviously not being a student or not being able to receive benefits from another place. And when I say student, obviously I'm referring to student loans, EI, CPP. There's an expectation that you'll exhaust all other government benefits available to you before you reach income assistance. So if you have clients who are looking to make an application, that's a good question to ask them, is whether or not they have access to other government programs that they might be able to seek first. So I'll move on to the next slide. So on a practical question, a lot of people ask, what do I need to bring to welfare if I'm going to make an application? And if you're dealing with somebody who has entered into the transition house system from an abusive situation and then is looking to, their next step essentially is to go in towards income assistance and to seek help, they're probably going to ask you what they need to take with them. The most important things they need are obviously their identification. So something that they can prove who they are, proof of a social insurance number, specifically the SIN number is actually quite important, and anything regarding proof of citizenship or their immigration status, which would show that they're eligible. The other thing, obviously, like I said before, is that you're often able to help with is any written documentation or any kind of written account of abuse that they have suffered, or that kind of account, so that they are able to specifically give it to the worker at the very beginning of their interaction. And it's important that the worker knows about it from the very start, because it starts the process differently from that very beginning. The little graphic I have below there is a graphic from a group called Raise the Rates, who's been campaigning over the last few years to raise the income assistance levels. And unfortunately, the most recent thing that I've heard is it doesn't sound like in the near future there's going to be a really strong impact on that. I think the government parties have come out with their platforms for the election. It doesn't sound like there's any significant increases to the income assistance disability levels. The only real progress I think that's been made is there has been a heightening of the amount of income that you can make while you're on assistance that isn't taken back by the government. So that's an ongoing issue, obviously, and one thing that you kind of have to prepare clients for sometimes is that even if they are able to access government assistance, it doesn't necessarily mean that they're fully taken care of. So very specifically, this question of exemptions for people fleeing abuse, there's multiple areas where it really comes into play. Like I said, in that financial independence question, there's quite a few exemptions in general for that, one being if you're under 19, if you're pregnant, if you're applying for persons with disability instead of regular income assistance, or if you've left an abusive spouse or moved to get out of an abusive relationship with someone other than a spouse. So another thing to keep in mind, obviously, is it doesn't have to be that spousal relationship. It can be a familiar relationship, and it can also be a sponsorship relationship. And that's something that's happened surprisingly more, I think, than a lot of people realize, is people having an immigration relationship with somebody, coming over as a sponsor to work in the home, and then experiencing abuse inside of that home. So the limitation there, the time limitation, is an important one, because they do actually place a 6-month limitation on that. So that's something very much to keep in mind. Time limitations are always very important, especially when you're dealing with anything legally speaking. And if somebody is looking to make an application for income assistance, it's definitely better if they're able to do that within 6 months of their situation change. Otherwise, they might run into that difficulty in proving financial independence if it's been 6 months since they left the family home or since they left the abusive situation. The same goes for employment plans. So after you're able to qualify for income assistance, there's an expectation that you'll have an employment plan. If you've left an abusive relationship, and if the abuse is a factor in keeping you from working, then it also will exempt you from having to go through the employment plan, which can be quite difficult for a lot of people. And below that is a couple specific situations with immigration, parents and individuals without status, single parents with a dependent child who's a Canadian citizen after leaving an abusive spouse with an outstanding application for permanent residency and cannot leave BC can qualify. So obviously, it can get pretty convoluted when it comes to who exactly qualifies and who doesn't, which is why a lot of the times you might be in a situation where really what you want to do is give somebody the basics and then hopefully refer them on to either an advocate or, if available, a lawyer to help them with their application process. One question that often gets asked is assets. So if somebody owns something, how does that affect their application for welfare? If they have a home or if they have a car, can they still receive benefits? With the family home is actually itself exempt. So if you do own a home, it doesn't necessarily mean that you have to sell that home before getting income assistance. One very difficult situation is when somebody is leaving a situation where they jointly own a home with someone, and if they've moved out and the other person still occupies that home, they may have to show to welfare that the other side is not willing to sell, isn't looking to liquidate those assets and make them into money so that that person would benefit from that. And obviously for somebody who is leaving a situation of abuse where contact is not possible, that could be difficult, and that's why, again, it's important that they specify that isn't something that they're able to provide. So very practically speaking, how can you help in situations like that? Like I said, the ombudsperson is always a good person to keep in touch with whenever you feel like someone's being wrongly treated by income assistance. Community advocates typically have a lot of experience in dealing with the income assistance and housing systems. So if you feel like you're in a situation where it's over your head, you can always take a look at who in your neighborhood or in your community works as an advocate and might be able to assist with those questions. There is a reconsideration appeals process as well, and typically speaking, it is complicated enough that you'll probably want to have someone who's worked in that system before take a look at it, but that being said, it is possible for anyone to help out with those. The most important thing to remember is that anytime you want to appeal a decision, anytime you want to reconsider it, you have to act quickly. You want to make sure that welfare knows as quickly as possible that that person wants to dispute it. And the last issue on this one is that question of family maintenance. So welfare often, well, they actually do have a specific policy that says that if you're capable of receiving family maintenance, spousal support, or child support, there's a requirement that you first try to obtain that from your partner before receiving income assistance. So there's an expectation the individual will do that themselves, will prove that they have tried to obtain that. In situations of abuse where that person has a fear of the other party, they do have the ability to exempt themselves from that, and they don't have to prove that they've tried to get family maintenance, but they must show proof of that fear. And that can come in the form of a court order, the court documents, if there's a doctor who's willing to say that the person is having that kind of fear or a psychological effect. A police report, if it's available, will definitely do the trick. And what's another key thing here is that the ministry has actually said specifically that a letter from a transition house or other agency providing support is all that person needs to prove that they shouldn't have to go through the family maintenance system. And there is actually a separate government family maintenance enforcement procedure that they take over the proceedings from you, and they'll probably do that. But the key is obviously making sure that a client who has a fear of their former partner or of that person that they're being asked to obtain money from isn't put in a situation where they're forced to have contact or to try to get that family maintenance from them. So that's another area where transition houses can be very, very helpful. As a resource, so everything that I've said obviously is very much an overview and very quickly kind of looking at the basics when it comes to it. There is a publication that Legal Aid created in partnership with a few organizations, I think, that's called Your Welfare Rights. There's a picture of it here on the slide, and there's the address where you can access it. It's very easy to find. If you actually just Google Your Welfare Rights BC, you'll find it in a number of places. It's one of the best, I think, legal resources that I've ever come across as far as really guiding you through a government administrative system. So it's a document that I currently always refer to whenever I get a question, even from something as simple as how much would I receive if I'm able to achieve benefits. There's charts in there that'll tell you that. If you have a quick question about welfare rights, this is a really great resource to look to, and it covers in greater depth the entire welfare system. Really quickly with disability, there's a couple things that you need to know, and the first is that to be effective, I think, in obtaining disability benefits and really having a good relationship with the government on disability, it's so important to have a good doctor and a doctor who's willing to advocate for the patient. I've seen a lot of cases kind of rise and fall on the strength of the doctor's report and the willingness of the doctor themselves to actually weigh in and to provide support. So if as an organization or as a community, if you're able to forge relationships that would help people connect with those doctors who have a better understanding of the issues, especially when it comes to abuse, if you're able to create those connections, it can be infinitely helpful for your client in the long run. And if they're able to secure a good doctor who's willing to advocate, then their first interaction from that point forward is going to be so much better with the system. So if they're able to obtain disability benefits, people on PWD have some rights that are above those of welfare, but surprisingly few, actually. I think a lot of people believe there's a stark difference between the two systems. There's not actually that profound of one. The health and diet supplements, for example, are available to everybody, and there's only one specific supplement called the monthly nutritional supplement that's available to people on disability. And again, for all of these things, you need an application form, and in that case, it needs to be filled out by a doctor, which the doctor would assert that person is in imminent danger if they don't have the supplement. So medical opinion is crucial. Bus passes are available to people on disability. Employment, education, training benefits above and beyond what you receive on income assistance is also there as well. And again, there's a different system for reconsideration appeals. So I've put the logo or the kind of heading of an organization called the BC Coalition of People with Disabilities on the bottom there. I would recommend them for all things disability related. I think they're really kind of the preeminent organization when it comes to advocating for disability rights, especially within the disability welfare system. So typically speaking, when I have somebody who comes to me and says they want to do an application for disability, or if they want to set up a disability trust, or if they're having problems with the amount of benefits they're receiving on disability, I typically refer them over to the BC Coalition. Even if it's something that I feel like I could do myself, I often like to refer to them just because I know they have such a good level of expertise in the area. I definitely encourage people to know a little bit and to learn a little bit about the welfare system and how it applies to their specific clientele, because I feel it is, whenever you're working with anyone who's in a situation where they're vulnerable or marginalized in any way, it's an inevitability, I think, that at some point they might have some kind of an interaction or need that crosses with that system. So commonly we have clients that have to engage with that system, and then a lot of the times they're looking for support. So it's always good to know the basics and to know when you can really help out and when you might need to refer out somewhere else. All right, so for lack of questions, let's move on and talk about Residential Tenancy Act and the world of housing in our province. So as everyone knows, housing is not the most friendly situation in British Columbia right now, especially for people who are low income. There are a lot of limitations on what kind of housing you can access, and kind of how you access that housing is also sometimes very determinant of whether or not you're able to ultimately obtain it. So one question that gets raised is, what kind of questions can landlords ask? What can they do to screen potential tenants coming in? Typically speaking, landlords can ask whatever they want to ask. The only thing that they can't do is cross over a line where they start to discriminate against somebody, and they have to discriminate against them if they're doing it based on these specific groupings that the Human Rights Code has created. So the most basic, obvious ones are if you discriminate against someone based on their gender, against their race, their sexuality. These things are covered by the Human Rights Code, and you can't deny somebody housing or anything, basically, on those specific things alone. But that doesn't necessarily mean that the landlord can't ask questions, and pretty far-reaching questions about what their prospective tenants are like. One thing a lot of people don't realize is if your client is on income assistance, the landlord also cannot discriminate against them for that reason alone. So if there's a situation where the landlord would have rented to an individual and then chooses not to because they find out that they're on income assistance or they find out that they're in care, that is actually a situation of discrimination. There's action that tenant can take against them. But beyond that, when a landlord and tenant interact, they create a tenancy agreement. Another misconception about tenancies is that if there's no written agreement, that there's no tenancy agreement at all. Whenever rent is paid from one person to a landlord, a tenancy agreement is created. If there's no paper agreement, the tenancy agreement just defaults to what is said in the Residential Tenancy Act. So everything that's contained in the Residential Tenancy Act, the very basics of tenancy in the province, those are all there no matter what, whenever you have a landlord-tenancy relationship that's created. So one thing to keep in mind is the material terms, as they call it, of a tenancy. So for example, one material term would be the number of people who are occupying a suite. If somebody moves in by themselves and then moves in 3 or 4 people without telling the landlord, that could be a breach of the material terms of their tenancy and could give grounds for eviction. Generally speaking, all conflicts that arise in a tenancy are governed by what's called the Residential Tenancy Act in the province, and there's a system in place where disputes can be taken. It was being called dispute resolution for a while. Now they're back to calling it arbitration. And pretty much all arbitration hearings are now held by the telephone in the province to cut costs. So generally speaking, if there's a conflict between a tenant and a landlord, there's paperwork that needs to be filed, documents served, and then a hearing takes place to try to resolve those disputes. One of the most common disputes, obviously, is that question of eviction and when a landlord can evict a tenant. The 4 most common ways that a tenant can be evicted: 10-day notice for a failure to pay rent, 1-month notice for cause, 2-month notice for renovations, or a 2-month notice for the landlord's use of property. So in the case of failing to pay rent, it's really important whenever somebody comes to you with an eviction notice to make sure that you know the deadlines and to advise them that they need to act very quickly. In the case of failing to pay rent, the person needs to take action within 5 days of receiving the eviction notice. And it's a really hard and fast rule. If they don't take action within 5 days, either paying the rent that's remaining or filing for dispute resolution to argue that they have paid their rent, or maybe there's a mistake, or that kind of thing. If they don't take that action within 5 days, the eviction notice will stand, and there's going to be pretty much nothing they can do. And the same goes for notice for cause. Notice for cause is the broadest section of evictions, and it covers everything from noise complaints to conduct. And in those cases, the tenant has 10 days to make sure they file the dispute and want to argue that they shouldn't be evicted for the cause in question. The other 2 are sometimes a bit more mathematical. If the landlord wants to occupy the building themselves, they do have a legal right to do that, and you can dispute that, but typically speaking, you will end up losing if the landlord is able to prove that they need to use it for themselves, and there's a 2-month eviction period for that. So just as an example, this is what an eviction notice, the top of an eviction notice for lack of paying rent, looks like. It's very important that you use the correct forms and the forms that are provided by the Residential Tenancy Branch. If the eviction notice doesn't come in the correct form, it's not actually a valid eviction notice. So if your tenant receives a piece of paper that just says scrawled on it, you're evicted by the end of the month. It doesn't actually work that way. So then that's just an example there of what that looks like, and typically speaking, if you've got a landlord that knows what they're doing, they're going to put it in the correct forms. But you often don't have tenants who understand the importance, I guess, of following the rules in that situation. On the flip side, the opposite of when someone's evicted, when can someone lawfully leave a tenancy? There's a requirement that a tenant give at least 1 month's notice if they're on a month-to-month lease that they want to leave the building. And if they're on a longer lease, if they're on a year-long lease, any kind of notice that they're breaking the lease will be seen as traditionally called a breach of contract. So one of the questions that's often raised is, if I'm in a bad situation, specifically if you're in an abusive situation, and you need to leave and you need to break that lease, what are the consequences for doing so? Practically speaking, almost always it boils down to the fact that if someone breaks a lease, if someone leaves early, they end up having to pay about 1 month's rent as a penalty to the landlord for breaching that contract. And unfortunately, we don't have a system in place where someone can prove that they should be exempted from that, or they should have been allowed to leave if they were fleeing a situation of abuse or violence. I think it's probably one of the biggest flaws or kind of holes in the current Residential Tenancy Act situation. And any time that somebody is given a financial consequence for leaving a situation of abuse is problematic. So there have been groups that have really been advocating for that to be changed, and I think there is some hope that after the next election, possibly, we might see some changes which give greater protection to people in those situations. But for now, if you've got a client who's left a situation like that, who's broken a lease, they do need to be careful about the fact that the landlord might be able to come after them for damages for that. That being said, the landlord does have a duty to mitigate their damages. That's the legal term. Basically, it means they have to try their best to either re-rent the suite or to not lose money if they've lost a tenant. So, I've had a lot of cases where people have tried to prove the landlord could have easily rented to somebody else. They had friends in place that wanted to move in, but the landlord chose not to have them. Strangely enough, like I said, almost every single case, almost every single time, it all comes down to the tenant having to pay a month's rent as a penalty. So I don't really know why that's the case, but it just seems to be the way that the arbitrators like to deal with these kind of situations. But it's always something to keep in mind that even if someone's staring at like a 2-year lease and they're thinking about breaking that because they want to get out of the situation of violence, there is a good chance that they'll be able to break that lease and they won't have to pay that much as far as the penalty goes. Because in British Columbia, with housing the way that it is, in most places, the landlord's not going to be able to show that they were unable to rent the property for too long because the demand is always relatively high. The other issue of leaving a tenancy and when a tenancy is completed is that question of damage deposits. I find damage deposits are one of the least kind of understood areas of tenancy law, and the thing that kind of impacts people the most when they're rapidly leaving a tenancy situation. The rules around damage deposits are very mathematical. They're very hard and fast, and there's not much leeway there. Basically, it says that within 15 days of a tenancy ending, an inspection needs to be carried out. It's the landlord's responsibility to instigate that inspection, and the tenant has to comply with it, as long as the inspection happens within 15 days. And the tenant provides a forwarding address in writing. They've essentially covered all of their bases for everything that they need to do. The forwarding address in writing is an important part, though, because if the address isn't given in writing, then you're not able to then later claim and get your damage deposit back until you've done that, even if they don't send it to you. The two big issues that come up with damage deposits is that question of what's wear and tear versus damage. Typically speaking, wear and tear means painting or carpets being replaced. All of these things that would have to be done over the course of a few years anyway. A lot of times people believe that, wear and tear means any kind of damage, but it actually generally means that over the course of time, things are going to have to be replaced, and one tenant shouldn't be themselves responsible for that. So Typically, landlords can't charge you for replacing carpets unless you've done clear damage to them, or for repainting the place unless, again, you've done clear damage. So those are things to keep in mind. There's a lot of fear, I think, that landlords will be able to keep damage deposits because of little things, but typically speaking, the threshold for a landlord being able to prove damage is actually a lot higher than a lot of people realize. Which is why the next thing, the waiver of the deposit, is so important. A lot of times people are asked to sign their damage deposit away because the landlord says, you damaged this, you damaged that, sign here. If you do waive your damage deposit, if you do sign it away, you're pretty much not going to be able to get it back. So if you dispute that in any way, or if you disagree with it, if you're in a situation where a client says, my landlord said I did all this damage, I don't agree with him, they need to make sure they don't sign anything and sign away their damage deposit, because they won't be able to retroactively go back and argue to get it. So taking action to get it back is essentially just filing with the residential tenancy branch. And like I said, if you've fulfilled all of those mathematical things, all those qualities, and the landlord hasn't returned your damage deposit back to you, there's an automatic penalty of double the damage deposit. And that is an award that I've seen handed out on many, many occasions. The last thing I want to talk about when it comes to tenancies there is this question of who is on the lease and what the rights are of a tenant versus a roommate. I've seen a lot of unfair situations come up when somebody is not actually on the lease themselves. There's somebody else who is. They pay rent to that person, and that person is essentially just that roommate. It is a very dangerous situation, and it's something to keep in mind, I think, because there's such a huge contrast between a tenant who has all the rights under the residential tenancy branch versus someone who's just a roommate and essentially has no rights, and they put themselves in a very vulnerable position because they don't have any property rights at all. If a conflict occurs in the home and that person leaves or is locked out, they might not be able to get back into the residence, for example. So generally speaking, there's a lot of positives to having tenancy rights, and if you're able to kind of get on the lease, then that's an important thing. So there's a question there: if you sign a sublease agreement, do you still have a tenancy rights? Signing a sublease agreement does give you the rights of the tenant. So it's essentially a transfer of the tenancy agreement from one person to the subleasee. The thing that you need to be careful about is when you've got a tenant who doesn't have any kind of agreement, just has people living in the suite and then is collecting rent and then paying the rent for that person, the landlord. The payment of rent itself is actually what creates the landlord-tenant relationship. And if somebody is paying rent directly to the landlord, more often than not, that will actually create the tenancy agreement and to give them rights. So in situations like that, I always advise people, if you can pay your rent directly to the landlord, then you should do that, because that might create a presumed tenancy agreement and to give you all the rights that come with that. That's what I wanted to cover on the housing front. I only have one slide left, actually. It's to cover the question of civil actions. Civil actions are basically everything that is encompassed that we haven't talked about. A lot of the times you'll get people asking you questions about one thing, welfare or housing, and that they also have this question of, well, I want to sue this person, or I want to take action against this person, what can I do about it? The civil law system is very, very difficult and very dangerous for people who are low income, because it's the one area of law where there really isn't any assistance anymore, hardly any assistance for people who are low income or who are vulnerable. Legal aid in the last 10 years has stopped covering anything civilly related. So if somebody wants to start a civil action, if they want to start a lawsuit up against somebody else for damages, they're more or less on their own, unless they can afford to purchase a lawyer or to hire a lawyer to do it for them. So, day in and day out, we're always constantly being asked for where can people go if they need help, if they need a lawyer for their case. These are the three referrals that I typically use the most. So I wanted to pass those along to you. A lot of the times I basically am just advising people to bypass the private lawyer system, because it's not worth your time and energy. If you don't have the money to retain a lawyer, chances are you're not going to be successful in getting one to pick up your case unless you have a really, really strong case and you're willing to do a contingency fee agreement, which is that a portion of the award goes to the lawyer. But more often than not, you're looking at someone who just needs help and is looking for assistance and guidance, and these are the places that I typically send them to. That being said, this is from the presentation I did last week, and it really is focused in the Lower Mainland. FNLC stands for the First Nations Legal Clinic, and it's a legal clinic that's in Vancouver for First Nations clients. It's similar to LSLAP, the one above it, which is the Law Students Legal Advice Program, which is run by the UBC, and it employs the law students to basically help out with legal cases. The bottom one, Access Pro Bono, is the one full-time kind of staff-lawyered organization that provides support for civil cases. They are shouldering a huge burden of the workload in the province now that legal aid is gone. So Access Pro Bono, for the most part, covers everything and anything, but it can often be difficult to translate that into something meaningful. And that's pretty much what I wanted to present to you guys about today.
Please stand by.